You know, Art Lasalento called me this week, and he asked me a question, and it had to do with Welfare and Institutions Code 827. And
Yes.
I thought, you know what, Jennifer's an expert at that. And he and I are on a case in a Northern California county, and we made a motion to disclose reports and records in this medical-based case to our own expert, our own medical expert, a doctor, a local guy here in the Pasadena area who's one of the preeminent experts, in child abuse. And you know what the judge told us? The judge granted it, but said, you don't have to make those types of motions if you're giving it to your own expert. It wasn't like, we were trying to blast it over the news. And, Art said, well, there seems to be, every once in a while, seems to be some type of conflict, like some judges believe that you have to do that. And this judge was of the opinion that you never had to do that if it's your own expert, which is something, that I would always think, if it was our own expert, it's part of the quote unquote law office, part of the attorney.
Well, one would think that.
Right.
One would think that, but 827 by its terms allows the court to distribute social reports and other documents in the case file to certain specific parties, of which a parent's attorney's expert is not one. That's the conflict. So the law is actually in conflict, I think, because the confidentiality provisions of 827 were never intended to limit a parent's defense in that way. Never intended. And while I could understand if the expert were taking the documents, copying them and stapling them on telephone poles throughout town, that would be problematic. There is no other way an expert can competently do his job for a parent defense without having documents. And if the expert were to put forth an opinion based upon anything but review of the documents, the court would not consider that opinion to be relevant because it wasn't considering the facts of the case. It would be an advisory opinion at best. So I definitely think there needs to be clarification. That needs to be done by the legislature. I too, last week, asked 3 courts for, I started by saying, I understand technically I should file an 827. However, I'm wondering if I could be authorized to share the social reports with my psychiatric expert, medical expert, whatever. And of course, no problem. So I'm just getting that noted on record. And it would be time prohibitive as well. These 827 petitions don't take priority on the case. And who knows when the judge will get around to deciding them. In that Northern California case, the judge was asked at the time and granted, but it is definitely an issue that some courts take a different view on.
I once had a judicial officer question me about doing that, about giving social worker reports to a psychologist who was my expert. And initially, I think that the judge believed that I couldn't do that and, was going to maybe even have a hearing or an OSC, against me for doing that. And I, mentioned, I didn't really argue. I go, basically, are you telling me I can't give the social worker report to one of my own experts? And it kind of blew over and we never had the hearing. But I think that the judge may have thought about it, how that sounded. In other words, when it mentions attorney in the code itself, in 827 of the Welfare and Institutions Code, in other aspects of the attorney-client relation, your experts, your employees are part of that quote-unquote attorney's office. So, for example, does 827 say that my secretary can't look at the file when she's
Exactly.
tab and indexing it? The same thing.
Exactly.
Same thing for an expert. And the experts all understand. Especially the guys and gals that do this frequently. That all of this is confidential. They're medical doctors. It's confidential anyway. So it would be kind of redundant. But I think that in other areas of the law, your expert is part of your office. And then, therefore, under CPS cases, your expert is part of your office as well.
That makes sense. I guess the sticking point is the confidentiality provisions, but it absolutely it just doesn't pass the straight face test. Mm-hmm. That because if it applied to an expert, it would apply, as you say, to office staff, to anybody, and that's just not functional. So it'll be interesting to see where that goes.
I also think that it would be if cases were done pursuant to the code and there was no breaks in the case, you couldn't do an 827 and get it heard before the time of the trial. Hey, would like you to hold on. We got to take our breaks here, our first break, and then we're going to come back and we're going to talk to Sheeta in California. So stand by. We'll be right back after these messages.